Hello, everyone, and welcome virtually to Notre Dame Law School. My name is Courtney Klaus, and I'm the chapter president of the Notre Dame Law School 2021 to 2022 chapter of the American Constitution Society. I'm here today with Janae Longenecker, last year's ACS president and one of the planners for today's event. We'd like to thank several co-sponsors, including Notre Dame LGBT Law Forum and the Notre Dame chapters of the ACLU and National Lawyers Guild. I'll turn it over to Janae to introduce our guest speaker for this afternoon, Professor Steve Vladeck.
Hello, everyone. The Notre Dame chapter of ACS is absolutely thrilled to welcome Professor Steve Vladeck as our speaker today. Professor Vladeck holds the Charles Alan Wright Chair in Federal Courts at the University of Texas School of Law. His prolific scholarship focuses on federal courts, constitutional law, national security law, and military justice. Professor Vladeck serves on the ACS Board of Academic Advisors, as CNN's lead Supreme Court analyst, as an elected member of the American Law Institute, and in many other professional capacities. You may also know him as the co-host of the National Security Law podcast and In Loco Parents. Professor Vladeck has argued before the United States Supreme Court and the Texas Supreme Court and has testified before numerous congressional and executive branch committees. He is currently working on a book titled The Shadow Docket: The Rise of Stealth Supreme Court Rulings and the Decline of the Court's Legitimacy. When it comes to the subject of the shadow docket, Professor Vladeck has had a busy last week. On Wednesday, he testified before the Senate Judiciary Committee, titling his remarks, "Texas's Unconstitutional Abortion Ban and the Role of the Shadow Docket." In the process, Professor Vladeck also became the subject of a rather iconic Twitter meme. And the next day, he was singled out in Justice Alito's address here at Notre Dame Law School as among the court's critics. We are particularly honored that in the midst of all of this, he made time to join the ND law community for today's conversation. Professor Vladeck, welcome to Notre Dame Law.
Thanks, Janae. It's really great to be with you guys, and I'm just so pleased to have this chance to talk about the shadow docket. I will try to avoid making any new memes. We'll see how that goes. So I think part of why this has become such a hot topic, obviously, is the Supreme Court's SB 8 ruling. As I think everyone knows, just before midnight on September 1st, in this 5-4 decision, this cryptic 5-4 decision, this is basically all of it. The Supreme Court refused to either block Texas's ban on abortions after the 6th week of pregnancy or vacate a Fifth Circuit stay that had barred the district court from blocking the law. But this was actually the third hugely significant ruling that the court had issued in just that first week. And let me make sure that I'm sharing my slides so you guys can see the show. So this was the third different major ruling the court had issued on the shadow docket in that same week. On August 24th, the court had denied the Biden administration's application for a stay of a district court injunction that had basically required the administration to restart the controversial Remain in Mexico asylum protocols. Just 2 days later, the court had also basically effectively nixed the CDC's eviction moratorium by vacating a district court stay of a ruling that had held the moratorium to be unlawful. And these three decisions together, the SB 8 decision by itself, not only brought new attention to the shadow docket, it also brought efforts to defend it publicly into the forefront. First, from Republican senators at the Senate Judiciary Committee hearing that Janae referred to last week. Second, of course, from Justice Alito in his remarks at Notre Dame last Thursday. And third, from the Wall Street Journal's editorial board last Friday in an editorial titled "The Shadow Docket Diversion." And so my talk today is basically a reply to these responses. So I'm going to talk a bit about sort of why this all matters from the perspective of the court's legitimacy, talk a bit about what we mean when we use the term shadow docket, really try to spend some time on what has changed in recent years, talk a bit about the causes of those changes, clarifying what critics like me are actually criticizing in the rise of the shadow docket, and then time permitting sketch out some potential reforms. So to foreground why all this matters, let me start with the court's legitimacy. One of the more remarkable things that I think Justice Alito said in his speech at Notre Dame last week was the suggestion that those who have used the term shadow docket to describe the rise of these kinds of rulings, we'll talk more about in a minute, are using it to portray the court, in his words, as having been captured by a dangerous cabal that resorts to sneaky and improper methods to get its ways. This portrayal, he said, feeds unprecedented efforts to intimidate the court or to damage it as an independent institution. Now, at least historically, the court has not framed its legitimacy as a function of outside criticisms. Rather, it's tied it specifically to its ability to persuade. So here's perhaps the most well-known discussion of this. This is from the joint opinion by Justices O'Connor, Kennedy, and Souter in Casey, where the court says that its power lies in its legitimacy, and that its legitimacy is very much tied to its ability to explain itself. That, quote, our contemporary understanding is such that a decision without principled justification would be no judicial act at all. Contrast this, right, and contrast Justice Alito's framing with a critique that Justice Alito did not mention in his speech at Notre Dame, the critique offered by Justice Elena Kagan in her dissent in the SB 8 case. At the end of her fairly short dissent, Justice Kagan said the majority's decision in the SB 8 case is emblematic of too much of this court's shadow docket decision-making, which every day becomes more unreasoned, inconsistent, and impossible to defend. So who has the better of this argument? In my talk today, I have two goals. The first is that I intend to demonstrate that Justice Kagan's critique is exactly right, that any comprehensive survey of how SCOTUS's approach to these rulings has changed in recent years would conclude that something is seriously amiss. And second, and perhaps just as importantly, I aim to convince you that such a conclusion is independent of the results that the justices are reaching in these cases and should thus trouble anyone who cares about preserving the court's long-term institutional legitimacy, even if they think the court is reaching the right answers on the merits. All right, so let's start by talking about what the shadow docket actually is. At the Senate Judiciary Committee hearing on Wednesday, there was this lovely moment when Texas Senator Ted Cruz said Democrats are fond of concocting ominous terms like dark money and shadow docket. Well, of course, the term was concocted by University of Chicago law professor Will Bode in 2015. This is an excerpt from his New York Times op-ed where he introduces the idea. And Will used the term as a reference to the obscurity of the Supreme Court's orders, not to any sort of shady, sinister implications, but just that they're obscure, they're weird, they're bizarre, they're not what we're used to reading. I actually think the metaphor is even more apt, though. So as I suggested last Wednesday, rulings on the shadow docket typically come after no more than one round of briefing, sometimes less. They're usually accompanied by no reasoning, let alone a majority opinion. They invariably provide no identification of how or how many of the justices voted, and they can be handed down at all times of day, or has become increasingly common in the middle of the night. Owing to their unpredictable timing, their lack of transparency, and their usual inscrutability, these rulings come both literally and figuratively in the shadows. But who cares what the name is? I mean, the terminology is not the story. We can call it the banana docket, and we'd be having the same conversation. What matters is what the court is doing in these orders. All right, so what are we interested in? Well, Professor Bode used the term to refer to all of the court's orders, the overwhelming majority of which are anodyne. I don't think anyone is writing their law review note on orders to extend the time for filing a brief. Justice Alito referred to it as a much smaller subset as the court's emergency docket. So just those orders respecting applications for emergency relief. I actually think it's, in between, that Will is right, that it's all of the orders, but it's only a subset of them that we're really interested in. Not just emergency applications, but orders granting and denying petitions for writs of certiorari. Those are and can be no less impactful. Summary cert stage rulings. This is what Professor Bode was focused on in 2015 when he coined the term. This may seem strange, but at least in this moment, motions to expedite consideration of cert petitions. So for example, in the SB 8 case, there's a pending motion to expedite the provider's petition for certiorari before judgment. Not hard to see how that actually can be very impactful, even though it's technical and often banal. And even miscellaneous but other sometimes significant orders in order to issue a mandate forthwith can have enormous consequences. An order for bail or for detention or for release from detention, which is rare these days but not in the old days, can have enormous consequences. So these are all different kinds of orders, not all of which are emergency applications, that can have significant real-world substantive effects. And that's when I talk about the shadow docket, what I mean. All right, now, defenses of the shadow docket all have in common the claim that, yeah, okay, fine, we've defined it, but there's nothing really new under the sun. And that's where I think the data is most harshly to the contrary. So this is Senator Cruz at last Wednesday's hearing. He said what Democrats are calling a shadow docket is the ordinary operation of every court that's been in existence since the ratification of our Constitution, whether a district court or court of appeals or the Supreme Court. The Wall Street Journal on Friday, why has what is formerly known as the orders list become a lightning rod? The short answer is that the Supreme Court has moved in a conservative direction, so Democrats in the legal establishment have ramped up the volume of their criticism. Okay, so there's actually data that gives a pretty clear picture, paints a pretty clear picture of some pretty significant shifts in these orders in the last few years that suggests that this is not just the same old, same old. We've seen a major shift in shadow docket rulings with respect to applications for emergency relief, including applications for stays of district court rulings, especially injunctions, stays of circuit court mandates pending certiorari, stays of execution for death row prisoners or removal for non-citizens facing deportation, writs of injunction directly against government officers, we'll talk more about those in a minute, and vacatures of lower court rulings granting any of those first four. So these are the bucket of emergency orders where we've seen such a real uptick in the last few years. And by tradition, these orders, like any order from the court, are unsigned and they're unexplained even when there are dissenters. So here is just a random example. This is a stay of a mandate in an Oklahoma case about the effect of McGirt versus Oklahoma. Here we have just a 1, 2, 3 sentence order with no analysis. This is the norm. This is the historical way the court dealt with most of these. Even when there are justices dissenting, as there are here, there are 3. Another part of the norm is that justices don't have to note their votes. Here we have 3 public dissenters, but we know from experience that there are stealth votes in these orders. When the court issues a signed opinion, the norm is to note how every justice voted or that they recused. Orders are different. Justices don't have to publicly note their vote, even when it's dispositive, as it was this February in an Alabama death penalty case, where one or both of Justices Alito and Gorsuch voted to not remove the lower court stay of execution, but we have no idea which one or why. And here's an example of how we can prove it. Here's a 2016 order in which Chief Justice Roberts explained why he was providing a 5th vote for a stay from which only 2 justices publicly dissented. I'm not very good at math, but I feel like at least 2 justices are therefore missing. Or I guess technically 1, since there were 8 justices on the court at the time. Okay, so the shift since the mid-2010s has had at least 5 components. First, there's been a significant uptick in total grants of emergency relief, and we'll get to that on the next slide. Second, these grants are not just more frequent, they're having much broader consequences. A stay of execution only affects the prisoner and the state in its ability to carry out a death sentence. A stay of an injunction allows a policy to go into effect that was otherwise blocked. Far more public dissents in both directions, respecting grants and denials, the invention of new forms of emergency relief, and the insistence that at least some of these grants should have precedential effects in other cases and contexts, even when they're accompanied by little, if any, reasoning. So let's walk through these. So with overall grants, here's a chart from my Senate testimony from last week. From October 2005 term, the first under Chief Justice Roberts, through October term 2012, so the first 8 terms he was on the court, really less than 5 per term. And if you actually take out stays of execution, that number goes down even further. Over the next 5 terms, that ticks up a little bit to about 10 per term. But over the 3 terms since Justice Kennedy retired, that's jumped up sharply to 18 per term, including 20 during the term that ended on Sunday. That's the most from any term I've ever found. So right off the bat, more grants of emergency relief. Now, some of this, but it turns out not all of it, can be tied to the Trump administration. The sharply changed role of the Solicitor General. During the Bush and Obama administrations together, so two very different two-term presidencies over 16 years. The federal government applied for emergency relief from the Supreme Court 8 times, so once every other year. 4 of those were granted. President Trump applied for emergency relief 41 times in 4 years. 28 of those were granted. And so far, the Biden administration is 0 for 1. This is a cool graphic from Law 360, building on some of my own prior work that visualizes just how dramatic the uptick was during the Trump administration. But of course, more applications doesn't necessarily mean more grants. We're also seeing different things happening within these grants. So again, more stays of district court injunctions, which allow policies that both district courts and circuit courts believe to be unlawful to go back into effect. More emergency injunctions directly against state officers where neither lower court blocked the policy and the Supreme Court is blocking it for however long the litigation takes. And more homogeneously ideological public dissents. So here's a good example of a pair of district court injunctions with no or little rationale. On the left is the January 2020 stay in the public charge case. On the right is the September 2019 stay in the second asylum ban. As you'll see, neither of these paragraphs offer any analysis. This is something we started to see a lot more of during the Trump administration, where you have immigration policies, other federal policies that a district court enjoins on the ground that there's the plaintiffs are likely to succeed on the merits, that a circuit court refuses to stay, and that the Supreme Court then stays. But the rise of unexplained stays is just one of the issues here, wholly unrelated to Trump. We've also seen, at least since last November, a remarkable uptick in emergency injunctions. So here's Circuit Justice Scalia back in 1986 talking about why emergency injunctions are actually even more rare. When lower courts have refused to block a policy, an emergency injunction, having the Supreme Court be the first court to intervene, requires an especially high showing because the court's acting directly against the political branches. And as Scalia points out, the court's authority is actually coming from a different statute, hence why it's narrower. So during Chief Justice Roberts' first 15 terms on the court, there's a grand total of 4 emergency writs of injunction. During the most recent term, there were 7. 4 of those were 5-4, with Chief Justice Roberts and the 3 Democratic appointees dissenting. The other 3 were 6-3. We're also seeing more and more homogeneously ideological dissents. It's not just that there are more dissents, it's that they're breaking the court right down into what we think of as the traditional partisan lines. So this is just a brief little accounting of how many orders each term there have been with public dissents from 3 or more justices. And you can see how October term 2020 was a rather remarkable aberration. And indeed, you can see this uptick over the last couple of terms. This is usually, especially during October term 2020, the 3 Democratic appointees and sometimes Chief Justice Roberts. Not always. There are a couple where it's also the conservative justices who are dissenting. Okay. What this also, I think, testifies to is of 68 total orders during the October 2020 term, from which at least 1 justice publicly dissented, there wasn't one in which a justice to the left of Chief Justice Roberts joined a justice to his right. There are no strange bedfellows here. In Justice Kennedy's last term, there were 2 shadow docket rulings with 4 public dissents. In his first 2 terms of retirement, there were 20. Even in October term 2020, the first without Justice Ginsburg, there were still 6 shadow docket rulings with 4 public dissents versus a total of 8 5-4 splits on the merits docket. So there are a lot more of these. And that's a pretty significant shift from what was true as recently as 3, 4, 5 years ago. Another pretty significant change that defenders of the shadow docket have not acknowledged is that the court is inventing new forms of emergency relief on the shadow docket. So here's a very technical but I think important example. Here's a California case where the plaintiffs had applied for an injunction because the lower courts had refused to enjoin certain COVID restrictions. And the court treats the injunction as a petition for a writ of certiorari before judgment, itself supposedly a rare and exceptional procedural device, grants the petition and issues what's called a GVR, a grant, vacate, and remand, where they vacate the district court decision in this case, a decision, mind you, not to enjoin California's policies, and remand to the district court for further consideration in light of another decision. I'll come back to that in a second. Before this term, I have not found a single example of this, a cert before judgment GVR, where there was no other related merits case. There have been 4 of these just during the October 2020 term. And guys, what I think doesn't come through in the slide, but comes through when you actually read it. South Bay United Pentecostal Church, the decision at issue here was an order. There was no majority opinion in the case that the Supreme Court is saying the district court now must reconsider in light of. Okay, a GVR is just a suggestion, of course, but the court is treating these orders as mandates too. So here, for example, is an order in another California case called Gateway City Church. It used to be axiomatic that summary rulings, especially those like South Bay, with no opinion of the court, had no precedential effect. Now the court's saying precisely the opposite. So here in Gateway City, the court says the Ninth Circuit's failure to grant relief was erroneous. This outcome is clearly dictated by this court's decision in South Bay. Again, a decision with no majority opinion. Gateway City, guys, is not a one-off. So here's Tandon, the 5-4 decision from April, where the court strikes down California's restrictions on in-home gatherings on free exercise clause grounds and writes a 4-page per curiam opinion to explain why. In Tandon, the 5-4 majority relies on prior shadow docket decisions, including concurrences, to grant relief, and again reprimands the Ninth Circuit for not treating prior unexplained orders as precedential. So the decisions in the left-hand passage on your screen refer to a single per curiam opinion itself in a shadow docket case, the Roman Catholic Diocese decision from November 2020, and a series of concurrences. But look at those 4 orders the court cites on the right-hand graphic. Those are all wanting for a majority rationale. Indeed, we just saw 2 of them. We just saw the orders in Gish and Gateway City. So the upshot of all of this is that anyone who claims there's nothing new under the sun, I think either hasn't been paying attention or worse, has been, because the data, I think, really does speak for itself. All right, so what caused all of this? The court's defenders, and now at least one justice, tend to identify some variation of 4 causes for these changes. First, there are more applications for emergency relief. Well, other than Trump DOJ applications, this actually isn't true. That the overall number of applications over term is actually going down a little bit. There's some noise in this data, but suffice it to say, it's not self-evident this is true. And second, it's also not clear why more applications means more grants. Again, the question is not whether there's an uptick in applications. The question is, why is there so many more cases where the court is granting this relief? Another common, but increasingly, I think, inapt defense is this is all response to the rise of so-called nationwide injunctions, or if we're going to be a little more technically accurate, plaintiff-oriented or plaintiff-facing injunctions. So again, I think the data doesn't bear this out. Even if you look just at the 41 Trump applications, only about half of those are actually about nationwide injunctions. It would also mean, of course, that circuit judges, not just district judges, are repeatedly erring. Remember, these cases are only getting to the Supreme Court. The court's only granting relief if the lower courts haven't properly granted relief from the justice's perspective. But third, if this is all really about nationwide injunctions, well, how to explain the Biden administration's one loss so far in a case it took to the shadow docket about MPP, where the Biden administration was subject to a nationwide injunction and sought a stay of the nationwide injunction. Again, there might be explanations. The hostility to nationwide injunctions can't be it. Another thing is Democratic judges were just out to get President Trump. Well, actually, there were plenty of Republican judges, including circuit judges, who were on the same side in these cases. And indeed, the trend has continued, if not accelerated, since President Trump's tenure ended on January 20th. Finally, and this is perhaps the most sophisticated defense, that it's due to broader doctrinal shifts facilitating certain types of claims. You'll hear folks refer to sort of vague theories of expanded public standing or associational standing. I'd love to see that expanded standing other than for states, but this still, even if it's true, doesn't explain the disconnect between the Supreme Court and the lower courts. It turns on facts, not in evidence. I actually am not sure where these doctrinal shifts have happened that are apparently motivating all of this new litigation. And so instead, as I testified last Wednesday, I really think this practice has become so pervasive that it's no longer possible to explain it away as a momentary aberration or as a response to any one external catalyst. Instead, I think the better view is that these changes are the culmination of a series of overlapping developments. First, and perhaps most nerdily, a series of very quiet, but in retrospect, fairly significant shifts in the court's internal procedures in the 1970s and 1980s, away from in-chambers rulings and in-chambers arguments and toward en banc, but not in-person disposition. The court used to actually formally adjourn when it rose for its summer recess, which meant that emergencies over the summer could not be resolved by the full court unless it came back for a special term, something it did 5 times in the 20th century. In 1990, the court very quietly changes its rules to shift to a continuous term, so that now the full court can act over the summer without reconvening. We also have the increasing centrality of the merits in emergency applications at the expense of other factors, especially the balance of the equities. And I actually think in his speech, Justice Alito alluded to this, that when the justices are making predictive judgments on the merits, perhaps it's not surprising that those judgments are coming out in a particular way. But of course, that downplays or altogether ignores the distinct procedural considerations that are supposed to be relevant in these cases. I think the obvious elephant in the room is changes in the court's composition, especially the last 2. You can see a pretty significant uptick in both the confirmation of Justice Kavanaugh, I think more because of the retirement of Justice Kennedy than the confirmation of Justice Kavanaugh, but also the confirmation of Justice Barrett. I think the injunctions we've seen over the last term, the 7 injunctions, at least 4 of them would not have been possible if Justice Ginsburg had still been on the court, maybe even more. And then finally, of course, far more aggressive litigation behavior by parties. So this is a lot of sort of broad data points and a lot of sort of high-level observations. Let's take one specific example. So here's the mifepristone case. During COVID, the district court in Maryland blocked an FDA rule that required particular abortion drugs to be prescribed in person in a physician's office. All other drugs, every other drug could be prescribed through telemedicine during a pandemic. And the district court found, I think not preposterously, that requiring those who are pregnant to actually go obtain this drug in person during the pandemic imposed particular harms and justified freezing the rule, at least temporarily. The federal government asked the Fourth Circuit for a stay. The Fourth Circuit declined. And so this begs the question, what is the emergency here? That is to say, what is the urgent situation where all these pregnant individuals have easier access to mifepristone? Maybe the district court was wrong, maybe it wasn't. But the notion that this was an emergency warranting the Supreme Court's review, I think would have surprised people as recently as 4 or 5 years ago. And yet on August 26th, DOJ applied for a stay of the district court decision. And 4.5 months later, on January 12th, the Supreme Court granted relief. During that same time period, within the time between which the Justice Department applied for a stay and the Supreme Court granted relief, the court agreed to hear, heard, and decided in a lengthy opinion the merits case challenging the Trump administration's plan to exclude undocumented immigrants from reapportionment. And so I guess all this is to say, whatever one thinks of the result here, this is not the shadow docket of yore. And so with the actual pattern properly described, let's turn to what the criticisms actually are, because I think there's also a fair amount of misdescription here as well. So in his speech last Thursday, Justice Alito identified what he described as 10 distinct criticisms of the shadow docket, and then proceeded to respond to them one at a time. To his distinct credit, that was the most sustained public effort by anyone to date to try to respond to criticisms of the shadow docket. I think we are all better off for the attempt. That said, whether or not Justice Alito accurately described the criticisms themselves, I think addressing them in isolation and or by identifying individual counterexamples that appeared to run counter to the critique really misses the mark. The problem is when you look at these things together. So, for example, right, imagine the confluence of these factors: the paucity, if not the absence of reasoning, the increasingly latent inconsistencies between these rulings, the uptick in decisions that appear to defy procedural limits, as in the mifepristone case, treating as emergencies some cases that just aren't, the absence of plenary review, especially where it was possible, so where you did not have some kind of crazy ticking clock, and I think most importantly, treating all of this as increasingly having precedential effect. It's when you add these things together that I think you really start to see why people like me are so concerned about this trend. And to illustrate how these tie together, let's put 3 October term 2020 rulings that produced the same 5-4 majority side by side. So I've already alluded to the Roman Catholic Diocese decision. This was 4 minutes before midnight, the Wednesday before Thanksgiving. A 5-4 court enjoined New York's COVID limits on in-person religious services on free exercise grounds, even though the plaintiffs were not at that moment subject to those limits. Now, we can get into a long discussion of mootness doctrine. I'm not sure as a constitutional matter the dispute was moot, but given the extraordinarily high bar for an emergency injunction pending appeal, hard to see how that kind of dispute meets that bar. Then, right, we get to Tandon in April, also shortly before midnight, this time about an hour and a half before midnight on a Friday. 5-4 court, same majority, enjoins California's household limits on in-home gatherings, again on free exercise grounds, based entirely upon a new interpretation of the free exercise clause. I have no beef here with that interpretation. People can debate whether it's a good interpretation or a bad one. The problem is that the All Writs Act, the source of the court's statutory authority to issue an emergency injunction, requires the rights to be indisputably clear. I'm not sure how a newly articulated right can be indisputably clear. And so those would be problematic enough in the abstract. You could perhaps tie them together by saying, well, the court's just erring on the side of overprotecting constitutional rights against aggressive new attempts to limit them. Well, if that's the through line, we come back to the SB 8 case, where on September 1st, 5-4 court refused to enjoin SB 8 because of a procedural question that it would have to answer, and that it did not actually answer before it could grant some relief. The problem is not, as it has been caricatured in the press, that the court didn't intervene in the SB 8 case. The problem is the inconsistency between these three, where the court is intervening aggressively at the expense of procedural limits to protect religious liberty in Roman Catholic diocese, where the court is intervening aggressively, perhaps in excess of its jurisdiction, to protect religious liberty based on a new theory of the free exercise clause in Tandon, and where the court finds itself tied in knots by a procedural question it won't even answer in the SB 8 case where it's abortion at issue. Multiply that, right? Extrapolate that to the vast run of the orders we're seeing on the shadow docket, to the orders that are producing divisions, and you start to see what the concerns are. And all of this has happened, and we should say, right, as the merits docket is shrinking. So here's a really cool chart by Adam Feldman that shows the number of merits decisions by term. And as you can see, even since 1988, when Congress took away most of the court's remaining mandatory appellate jurisdiction, it hasn't been fixed. It's been continuing to decline into the 80s, in the late 1990s and 2000s, into the 70s, in the late 2000s and early 2010s, and into the 60s and now 50s today. Now, of course, correlation is not causation, but it seems only natural to assume that the dramatic uptick in volume, in significance, in divisiveness on the shadow docket is at least somehow related to the continuing shrinkage of the merits docket. And of course, that too has implications insofar as it impedes the court's lawmaking abilities and lawmaking functions. All right, so tying all this together, right? My criticism is not about any one feature of the rise of the shadow docket. It's about the overall pattern reflected in that rise and the deeply problematic impression that pattern conveys. In both absolute terms and relative to merits cases, the court's handing down far more and far more important rulings on the shadow docket. The rulings are usually either unexplained or inadequately explained. They appear in some cases to flout settled procedural constraints. They appear across a larger set of cases to be analytically inconsistent. And even the unexplained rulings are increasingly treated as precedential, so that perhaps it's not surprising that these rulings are dividing the court uniformly on ideological lines. Rather than acknowledge these concerns, recent defenses of the shadow docket have turned to criticizing the critics. Instead of rebutting any of these observations, which people like me have been making for years, the fallback response is that we just don't like the results that the court is reaching in these cases. Of course, this implies bad faith, despite the absence of any evidence of such, but it also ignores that a core objection is insufficient reasoning. If I don't like the results, why would I want the court to provide a more persuasive and precedential rationale, as it did, for example, with regard to the CDC's eviction moratorium, where it wrote an 8-page opinion explaining why the moratorium was almost certainly beyond the CDC's statutory authority under Section 361 of the Public Health Service Act. But it also more fundamentally ignores the court's own insistence that principled and consistent legal justifications for its decisions are central to its legitimacy. That the court has not offered such rationales for most of its shadow docket rulings raises legitimacy concerns, even if it is getting the results right. All right, so in the slides, in my testimony, I've sketched out some reforms. I don't want to sort of walk through them too much here because I know we're short on time. I'm happy to talk about this more in the Q&A. Let me skip ahead to sort of the end of the story and then turn it over to Professor Bray. So I end where I started, which is with the court's own understanding of its legitimacy. If we agree with the suggestion in Casey that the court's legitimacy depends on making legally principled decisions under circumstances in which their principled character is sufficiently plausible to be accepted by the nation, then it's not hard to understand why, for so many, recent developments on the shadow docket raise serious legitimacy concerns. That those concerns are not shared by many who think that the court is reaching the correct bottom line results in these cases may speak as much to their true principles as it does to our critiques. So let me just say thank you again for taking the time to join us today, and I'm really looking forward to Professor Bray's response and to your questions.
Thank you so much, Professor Vladeck. Professor Samuel Bray will now offer a brief response. Professor Bray teaches here at Notre Dame Law School, and he is a leading scholar on constitutional law, remedies, and equity. Someone else next semester may also notice that he is the author of one of the authors on their constitutional law textbook. Professor Bray is a fellow of the Notre Dame Program on Private Law and a McDonald Distinguished Fellow at the Center for the Study of Law and Religion at Emory University. He is the chair of the Association of American Law Schools Remedies Section Executive Committee. He is an advisor on the Restatement of Torts Remedies and is a member of the Advisory Committee for Rules of Procedure for the United States Court of Appeals for the Seventh Circuit. Over the summer, Professor Bray testified before the Presidential Commission on Case Selection and Review at the Supreme Court of the United States. In his testimony, Professor Bray addressed the increasing number of cases on the court's shadow docket through the lens of his expertise regarding remedies, particularly national injunctions. Professor Bray, thank you for being here today.
Thank you. It's an honor to be with you all and to have the chance to continue this discussion with Steve. I want to first applaud ACS and the other student groups that are sponsoring this. I think one of the most important things student groups can do is encourage a robust debate on campus, including serious contestation of ideas. And these are important ideas that people in law schools need to be thinking about. So I want to pose a kind of a nuance, a prodding, and then maybe a dilemma for the future. So the nuances on the causation story, there's a lot here that I agree with that Professor Vladeck said. And there's also overlap between what he said and what Justice Alito said, though there are some differences. I do think the national injunction has a bigger role to play in this than Professor Vladeck would indicate. And I think the story here, he's absolutely right that the national injunction is not most of the applications. But I think there's a path dependence, as is often the case in law. So the big change is once the national injunction starts to be used, first against President Obama in the last couple of years of his administration, then against President Trump, and then there's strong pushback by the Department of Justice under President Trump. Then what you see is the court the district courts are giving national injunctions, the DOJ is responding, the court is responding, and then once there is this avenue for more emergency relief, then you start to see it used and picked up by other parties. So one of the 4 parts of causation that is given in the story by Steve is other parties and their behavior, and I think that's exactly right, but I think that's in the slipstream of the national injunction. Now, there's definitely been inconsistency in what the court has been doing, and I think what we see here is a little bit the court muddling along and trying to think through this new development and think through what its approach to it should be. And I think nowhere is this clearer than on the question of whether there's precedential effect to orders in the shadow docket. Justice Alito took the position that there should not be precedential effect. I think that's good, and that's what some commentators have urged the court to do, and Professor Vladeck seemed to take that position today, and that's good. And that is a good defense maybe now of what the court's doing, but doesn't fit with some of the COVID religion cases. But I think just as the court has been like trying to figure out its position on something like that, there's also been a little bit of shift in the commentators and the critics. So if I can go to the prodding, I think my prodding is going to be also start from a point of agreement. So Professor Vladeck said, set aside the merits. And I do think that's important. You can agree with the court on the merits. You can disagree with the court on the merits. If you disagree with what the court's doing on the merits, you're not going to like any of the dockets, shadow or not. And whether you do or not, we can separate out the procedural questions. But once we separate out the procedural questions, and once we have concerns about big tectonic decisions being made without full briefing, then that brings us to something like Whole Women's Health versus Jackson, where the Supreme Court did not, as asked to, stay any of the lower court orders. Now, in that case, I think there's some serious cognitive dissonance between two of the dissents. And these are the dissent of Justice Kagan, which was quoted by Professor Vladeck, and the dissent of Justice Sotomayor. And I can understand the position for each of those. The position for Justice Sotomayor is merits are so important, constitutional right at stake, court should jump in. Why do we wait 48 hours? Justice Kagan position, 48 hours, we're asked to make a big question, answer a big question. We shouldn't be doing this on the shadow docket. Now, the Supreme Court didn't reach out for this. This was the abortion clinics in Texas that decided to ask for the emergency relief, and the Supreme Court declined to give it. Now, it gave an explanation. I think it was a very good explanation, citing its recent, I believe, 7-2 decision in California versus Texas. And so it gave an explanation for why it wouldn't be right to do this. And but I think there's serious cognitive dissonance there. You can't, on the one hand, say the court should have given an emergency order and it should have done it really quickly. And by the way, the court shouldn't be doing emergency orders. And it's fine to say, oh, this case and that case are inconsistent, but the critics of the court themselves need to be consistent in the positions they embrace. And I can understand wanting to join one of those or wanting to join the other. By my lights, the Kagan dissent should have been a concurrence in the judgment for the court, or like agreeing in effect with how the case came out, even if you didn't necessarily agree with the majority's one paragraph opinion. Last point, we're going to move in one direction or the other. And I think this is one of the most interesting things about this area. Right now, these orders have this like in-between quality. Sometimes the court gives them precedential effect, but maybe it's going to get out of the business of doing that. That would be good. Sometimes it gives some reasoning, but it doesn't give the full gold-plated reasoning. And one way to look at this is that the court should move all of these to being more like its regular docket. And the court has done some of that recently. The religious liberty execution case, Ramirez, the court scheduled it for full argument on an expedited basis. And so once again, I think this is an example of the court developing and the court's responding to the critics. And so some of the critiques that Professor Vladeck has been making, it seems to me that the court is actually changing and moving more in the direction he's wanting. But the other way the court could move these cases is move them to be less precedential and give them less effect like the other ones. And I think each of those is an understandable equilibrium. And I think it's that we're kind of in the in-between space, the liminal space that makes it a little more confusing. I think most of these should move in the direction of being give less reasoning and give less precedential effect. I think that's the better equilibrium. So in conclusion, let me just say something about terminology. The shadow docket is the conventional name, and I'm happy to use it, but I do think it's got this connotation that is not correct, that it's sinister. It's the shadowy docket. If you're a fan of Bleak House, you know chapter 1 has all the fog in Chancery, so you could call it the fog docket, something like that. And I don't think that's an apt description. I think it's shadowy. Shadow docket would once have been correct in the sense of the less noticed docket. But I think that's less true now, and thanks in part to the redoubtable efforts of our speaker today. Thank you for the chance to continue the conversation.
Thank you so much, Professor Bray. We will now turn to questions which have been submitted from members of the Notre Dame Law School community. So the first question, I think, gets at some of what Professor Bray raised here. The student asks, "It is my understanding that the court is often left with very little time to decide these shadow docket matters. If we demand every grant of an injunction or stay to be supported by thorough judicial reasoning, don't we risk having the court promulgate rushed and haphazardly construed law?"
It's a great question, and the short answer is yes, which is why the court has mechanisms to deal with that. So take the MPP case. So in the MPP case, you had a nationwide injunction entered by a district court. You had the Fifth Circuit refusing to stay that nationwide injunction, which was about to go into effect. And you had the federal government applying to the Supreme Court for a stay. Justice Alito, in his capacity as circuit justice, issued an administrative stay, a one-sentence order all by himself, with no reasoning, with no presidential value, that simply froze the law the way the federal government was asking for long enough for the court to decide whether to rule and which way to rule on the stay. 4 days later, of course, the court rejects the government's application over 3 public dissents. So the court has ways in response to the question of buying itself time. It's also worth noting, I mean, Justice Alito made the same point in his speech last Thursday in specific reference to the SB8 case. Yes, the ruling in the SB8 case came at 11:58 p.m., not the night the law was supposed to go into effect, but the night after the law went into effect. So, I think this, and this ties together with one of my responses to Professor Bray's helpful comments, which is, I think the notion that it's all unidirectional, that people like me want the court to either always intervene or never intervene, is just not accurate. It's not what Justice Kagan said in her dissent in Jackson. She was not saying like we should be intervening or we should not be intervening. She said the problem is that these rulings are unreasoned, inconsistent, and impossible to defend. And so my response is yes, there are going to be some genuine emergencies. No one, despite what Ted Cruz might think, is arguing that the court should lack the power to respond to genuine emergencies. The question is, how can we get the court to do so in a way that absolves it of the charge, that it's doing so in ways that are unreasoned, inconsistent, and impossible to defend? And the pattern we're seeing, right? Sam's exactly right. Professor Bray's exactly right, is in this liminal space between a very consistent, we're going to do lots of big stuff on the shadow docket and we're never going to do anything. And what's really frustrating about that is the inconsistencies just happen to break down in favor of blocking blue state rules, blocking Biden administration rules, allowing red state rules, allowing Trump administration rules. Maybe there are good explanations for why the pattern is so uniformly that, but in the liminal space, without these explanations, that's the source of the problem.
Thank you. So we'll have a second question from the audience, which gets at maybe a little bit of what Professor Vladeck had hoped to get to in his initial presentation. Is there anything Congress or the president can do to limit the use of the shadow docket?
So the short answer is, I think there are actually 2 different, very big things Congress can do. The first is Congress can take pressure off the shadow docket. So, if Congress agrees with Professor Bray that the universal injunction really is such a big part of the problem here, Congress can change the relevant procedures. Congress could, allow the federal government to transfer any lawsuit seeking relief that's properly characterized as nationwide to the DC federal court, so you don't have the concern of judge shopping. Congress could provide for immediate expedited appeals of district court decisions regarding nationwide injunctions. The same is true in capital cases, right? These 11th hour method of execution claims, or Sam mentioned the Ramirez case, right? The sort of who can be in the execution chamber cases. there are ways to actually make sure that those claims don't have to come up, at 6 p.m. on the night of a scheduled execution. So in regards to taking pressure off, there's one whole set of reforms Congress could pursue on that front. I think Congress could also even get a bit more aggressive. So one of the reforms I propose is that Congress simply codify what the Supreme Court has long said are the appropriate standards for a stay or vacating a stay, for an injunction or vacating an injunction. I actually think Justice Alito misdescribed my proposal in his speech last week. I'm not suggesting we raise the standard. I'm saying we write it down. Because insofar as we think the court is not following the standard, perhaps codifying it would reaffirm that Congress meant it. But also, and Courtney, more generally, I think for 33 years, Congress has largely stayed out of any regulation of the Supreme Court's docket. And I think we're seeing the effects of that, not just on the shadow docket, but in the decline of the merits docket. If this is part of a broader conversation about Congress getting back into this inter-branch dialogue with the courts, a dialogue Congress was perhaps the lead player in for the better part of 200 years, I think that would also be a good thing.
Thank you, Professor Vladeck. And we'd also like to give Professor Bray the opportunity to comment on his suggestions or reply to Professor Vladeck's suggestions.
I like the idea of Congress getting back in the business of interbranch dialogue with the courts. The question of jurisdiction stripping, for example, and other ways in which the Congress is supposed to regulate the court's jurisdiction has been episodically important. But it's a reminder that the Constitution doesn't belong just to the court. The Constitution belongs to all three branches, and more importantly than that, the Constitution belongs to all of us. It is the work of we the people.
Okay, thank you. Our next question turns attention a little bit towards the media. And so this question asks, recently, it seems that the more reserved members of the court have become more outspoken with their criticisms of the court's media coverage and their insistence that the court does its best to avoid political frays. How much of the justices' criticism of their media coverage is fair? And why do you think the more reserved members have become more vocal recently?
Well, I think I should remind folks off the top of something that Janae read from my bio, which is that I am CNN Supreme Court analyst. So I have some thoughts about this. It's pretty typical for everybody, and Supreme Court justices are not immune from this, to blame all their troubles on the media. I think some of that criticism is not completely unfair. I mean, Dahlia Lithwick and I wrote a piece for Slate at the beginning of last week about what to us is the unfortunate way that the media tends to cover the Supreme Court, focusing on the accessible big picture merits cases at the expense of perhaps the more important merits cases and the shadow docket. I will say, though, that in this context, the criticism of the media, which at least in one case came in a speech that was not recorded and to which the media was not invited, does ring a little hollow. Where, back to sort of where I started my talk today, if the court wants to persuade us that what they're doing is backed by deep, consistent legal principles and is not just, because of who's in charge at the moment. The way to do that is to convince us through their explanations, is to convince us through their decisions, is to write more when they can in these shadow docket cases. And frankly, not to give speeches that the media can't go to, blasting the media for misdescribing what the court is doing. I guess to me, there's more than zero truth to the fact that I think the media doesn't get the court right. But from the perspective of the justices complaining about the media's responsibility for eroding the court's legitimacy, I think at least some of that responsibility starts from within.
I am going to take a different tack here, and I think the media does deserve plenty of blame for this. So 3 quick points. One, Justice Thomas gave a talk at Notre Dame a couple weeks ago, and his lecture was almost entirely about his autobiography, his personal experience. It was moving, and also about the importance of the Declaration of Independence in American history. That, of course, is not what you would have understood from the reporting of the event, which focused on the media in response to a question I believe he got. So that distortion, that prism through which he was presented is not a good one. Second, I think a very unfortunate development has been to tag every judge by the appointing president. and then treat every judge as a partisan actor. Now, I'm not saying that political views have no bearing on the court. I'm not naive like that, but I do think that is a bad effect on our view of the courts. And they're not elected to be a Republican judge or a Democratic judge. And so we should do what we can to tamp that down rather than increase any kind of sense of political representation. And I think that's happened. And you can look at media stories now compared to 10 years ago, and the trend is very sharp in that direction. And last, I think it would be good to highlight more points where there's agreement and disagreement. So that's even true for today. So if I can, Steve, since you are a CNN analyst, I will include you in both the distinguished member of the Legal Academy and you have a media hat. There's a lot of points on which you and Justice Alito align. Like some of the points of causation, there's a lot there. And his response to you in particular, your proposal, even if he didn't get the proposal exactly the way you want it to be, like he said, there's some merit to that. So I think treating it less, I mean, the quotes from Cruz do seem like a kind of a black and white difference with what you're saying. But I think noting the degree of overlap in critics and defenders would go a long way toward helping our conversation about these topics.
Okay, I just want to show something really quickly. This is where the Supreme Court posts the justices' public speeches. This is the website where that happens. I don't know how well you guys can see this, but the most recent entry is Justice Ginsburg in August of 2019. So, I mean, yes, the media could do more to cover the more technical and the more sort of interesting but not sensational parts of the court's work. But the justices have some responsibility here for not necessarily, leading the way when it comes to transparency.
This is great conversation. We'll kind of going off of the same sort of idea, go to another question from a student. What would you say to the idea that the Supreme Court has not changed, but rather the political landscape has? It would seem to me that politicians as of late are just taking more controversial action, which require immediate and brief response to prevent irreparable harm.
So, I mean, I think there's no question that some of what we're seeing is related, at least loosely, to broader polarization in our polity and our political culture. I guess certainly some of what happened with the Trump administration was, federal, especially district judges and circuit judges responding to a rash of new and controversial policies. But of course, the Supreme Court stayed most of those injunctions. I'm old enough to remember, 147 years ago when President Obama came to office, and all of his policy initiatives were challenged in court. President Bush, many of his policy initiatives were challenged in court. So, yes, we are more polarized. I think the court is more polarized. I mean, that seems to be, is absolutely undeniable. I think the departure of Justice Kennedy, where there's no longer, a sort of a median voter who the two sort of camps are worried about keeping on sides, has been a big part of the story. But the notion that this is all just because governments are more often doing more unlawful things, I think that's a little inconsistent with history. And if it were true, then what that really means is that there is a epidemic of bad district and circuit judge decisions. That, all of these just sort of bad government programs should have been just stopped by all these district and circuit judges. And one would think the Supreme Court would take efforts to say, hey, district courts, hey, circuit courts, here's what you're doing wrong, right? Here's how you're misapplying the standards. Here's why we keep reversing you on the shadow docket. So again, yes, I mean, Sam's right. We might actually agree loosely. Justice Alito might agree loosely, right, on some of the causes here. That doesn't actually excuse the court's actions, right? Because whatever is the cause here, the court's not doing enough to tell us in a way that's going to help ensure sort of neutral ways out of it going forward.
Professor Bray, would you want to respond to that briefly? And then we can, oh no, you're okay.
Nope, all good.
Okay. So maybe we have, I don't know, we're almost out of time, but we can ask one more question. So this one asks, As students in con law and federal courts, we hear a lot about the importance of an independent federal judiciary. Federal judges are contrasted with state judges because of their lifetime tenure and salary protection. And yet, even members of the Supreme Court seem to be deeply concerned about public perception, as evidenced by recent public speeches. How should we think about judicial independence in this context, and how much does public perception of the court really matter?
Such a neat question. I mean, I think the short answer is they're deeply related. In other words, right, that the Supreme Court's independence is what protects it from political retaliation. But of course, independence of itself could be a weapon, right? And so that's why I think the court has always understood its legitimacy, at least part and parcel by reference to not public support for its decisions, but public acceptance that what the justices are doing is exercising judicial power as opposed to political power. And this is something I really try to harp on in my first year con law class. Like, you can think a decision is right or wrong and have the opposite view about its rationale, right? That's the beauty of our system. It's the rationale, to me, where the court gets its legitimacy. It's the effort to persuade us that there are deep legal principles that amount to more than just, I'm ruling for this guy, but not that guy. I'm ruling for the person from my party, but not the person from the other party. And if anything, I think that's what reinforces why I, at least, and I can't speak for others, am so concerned about the shadow docket, because the more, it is increasingly clear, whether, as Sam suggests, because of my efforts or otherwise, that people are paying more attention to this. I think that's a great thing, but with that more attention comes more scrutiny. And I think the more that folks are scrutinizing this, the more they're realizing that the court is not adequately explaining itself. And that's where, so that's why sort of I end where I started, which is judicial independence is incredibly important, but it's not, it is not everything. Independence also implies legitimacy, or at least it requires legitimacy to be effective. And so the legitimacy part of the story, I think, is what doesn't get enough attention. And it's where, to me, all of the overlapping currents that have led to, these concerns in the last couple of years really do raise legitimacy concerns, even if you think the court's getting the bottom line right in all or even most of these cases.
Thank you, Professor Vladeck. And with that, I want to thank everyone for coming today. I want to thank Professor Vladeck. Thank you so much for coming and speaking to Notre Dame law students today. We're really glad that we could get you to come talk to us, and thank you. Professor Bray, thank you so much for offering your input, and we appreciate you being here as well. Thank you to the NDLS community for its tremendous support, and thank you to our co-sponsors, once again, LGBT Law Forum, ACLU, and National Lawyers Guild. Thanks so much, and I hope everyone has a great afternoon.
Thank you, guys.